CLR 2A. So this is 2019 quiz 2A. 1. In any action or proceeding brought to review or determination of the Chief Judge of the Court of Appeals or the Administrative Board of the Courts, the proper party is only the fucking Chief Administrator. That's it. You're never allowed to name those other people, the Administrative Board of the Courts or the Chief Judge of the Court of Appeals. You have to just sue the fucking Chief Administrator. 2. When constitutionality of a statute of the state is involved in an action and the state itself is not a party, the Attorney General shall be notified and shall be permitted to intervene in support of its constitutionality. So public retirement benefits, when those are at issue, that's the comptroller. But when constitutionality is involved, it's the Attorney General, and he's permitted to intervene. 3. Which are true regarding interpleader? Concerning interpleader. 1. There must be at least 2 parties. That's true. 2. The defendant stakeholder may bring in a claimant who is not a party by filing a summons and interpleader complaint. That's also true. Number 3 is wrong because even if the claimants do not have a common origin, you can still maintain an action of interpleader. I don't really understand what that means, but the answer was B, 1 and 2, but not 3. Number 4. True or false? When authorized by the fucking Chief Administrator, filing of papers to commence an action may be by electronic means or fax, and that is true. 5. 5 is false because it's a confirmation record and an affidavit, okay? That's the evidence you need for service. It's not just a confirmation record. You need a confirmation record produced by the filing party's machine and an affidavit. And it's prima facie evidence that the filing party transmitted documents consistent with the date, time, and place appearing on the confirmation record. 6. In order to effect service by publication, the plaintiff must obtain a court order. The first publication shall be made within 30 days after the order granting service by publication. 30 days. 7. Mary sued Jeannie for $27,500. Jeannie did not counterclaim. Okay, basically what this is with consent. So in New York City Civil Court, you're going there with consent. That means that the amount is reduced to $25,000. Now, this question said select the incorrect statement. Okay, so if you looked at it and you're like, oh my God, you know, they're all look kind of true to me, except maybe the first one. Then hopefully you went back and so it said select the incorrect answer. The incorrect answer is A, because Jeannie's attorney doesn't have to consent to the transfer. Only Mary's attorney does, because there's no counterclaim. And as you'll see in question 8, it doesn't even matter. They can do it anyway. But once they consent under 325C, the New York City civil judge cannot issue a subpoena to produce a prisoner, and the amount that Mary can be awarded is $25,000, which is the limit in New York City. Everywhere else, I think it's $15,000 for like the lower court amounts. And a waiver of jury trial is inoperative following the transfer, and that is true, because just because you waived, maybe you really like the justice that you were going to be in front of, but now you're going to New York City Civil Court and you don't even know them, so now you're like, wait a minute, maybe I do want a jury. So that's why it's inoperative after the removal. Now, question 8, I'm not going to read the whole thing, but the main key here is no consent. Vinny will not consent. So, what are we looking for? We're looking for the correct statement. A waiver of jury trial is operative. No, it's inoperative after the removal. B, the verdict or judgment shall be subject to the limitation of monetary amount where the action was removed. No, because this is without consent. That's the biggest difference between 325C, which is in question 7, and 325D, which is in question 8. In 325D, where there's no consent, you can be awarded $1 million in lower court because your case was removed without consent. And another tidbit to note is that in New York City Civil Court only, the judge also then gets the power to issue a subpoena to produce a prisoner. So the answer here was C. The verdict or judgment shall be subject to the limitation of monetary jurisdiction of the court in which the action was originally commenced. Oh, I just found a typo. Put the word "the" twice. Okay, so that was answer C. 9, true or false? An order to stay proceedings for the purpose of moving for removal may be made in the court in which the action is pending or the court to which removal is sought. And that is true. 10. Upon application by any interested person or in response to letters rogatory issued by a tribunal outside the state, the B, Supreme or County Court may order service upon any person who's domiciled or can be found within the state of any document issued in connection with the proceeding in a tribunal outside the state. So if someone is suing me in California, they can't get me served with a piece of paper. They can come here and try to get the Supreme or County Court to order service on me. The order shall direct the manner of service. 11, true or false? Personal service upon a partnership may be effected by serving the summons on the person in charge of the office of the partnership within the state, and also mailing the summons to the partner to be served by regular first-class mail. Proof of service shall be filed within 20 days thereafter, and that's true. The best way is to personally serve one of the partners, but if you can't, you could deliver the summons to the person in charge of the office if they have an office in the state, and then you just, by regular mail it to one of the partners. And then, of course, there's the 20-20-10 rule, which is 20 days after you drop it off at the office, you have to mail it to the partner, and then 20 days after that, you have to file the proof of service, and then 10 days after you filed the proof of service, service is deemed complete. All right, 12. True or false? And this is false. Service on 15-year-old infant may be effected by serving the summons on his parent. False. You also have to serve the infant. So if they're 14 or more, you can't just serve the parent, guardian, whatever. You have to serve the infant as well. The same thing with like an incompetent or conservatee. You have to serve both the committee or the conservator, and you have to serve the incompetent person or the conservatee. And the court can dispense with service on the incompetent and conservatee, but the court cannot dispense with service on an infant who's 14 or older. Excuse me. 13. Unless the party is a person specified in CPLR 1201, infant, incompetent, or conservatee, an attorney of record may be changed by filing a consent to change attorney, signed by the retiring attorney, and signed and acknowledged by the party. Notice of such change shall be given to the attorneys for all parties in the action, or if a party appeared without an attorney, to the party, so that they know who to serve papers to. 14, true or false? After service of her answer, a defendant may proceed against the person not a party by filing a third-party summons and complaint with the clerk of the court in the county in which the main action is pending, for which a separate index number shall not be assigned, but an index number fee shall be collected. So you pay the $210, or whatever it is, the index number fee. You pay that money, but you don't get a new index number. You just still have to pay the fee. 15. The third-party summons and complaint shall be served within 120 days of the filing. So the same as a regular summons and complaint, third-party summons and complaint also has to be served within 120 days. 16. Unless the court orders otherwise, if the making of a motion for a new trial or for taking an appeal, has not yet expired before the occurrence of an event permitting substitution of a party, the period is extended to all parties until 15 days after substitution is made. 17. Which of the following is grounds for dismissal of an action without prejudice? And the answer is A, non-joinder.